Please the court. Please the court. I'd like to address a couple. I'd like to address a couple. Move on to some more substantive. Before I move on to some more substantive. I believe it was Justice Sullivan who. Asked whether the legislature could. Whether the legislature possible that the legislature intended for life intended for subsection 2B as it applies to juvenile 2B as it applies to juvenile first-degree murder. Legislature could have intended that legislature could have intended that parole irrespective of the parole irrespective of the parole statute and counsel responded. I think possibly that is very telling. I think at the very least, while we would assert that it very we would assert that it very indicate that the legislature indicate that the legislature intended that. We would assert at the very least that there is some ambiguity as to whether the state or the legislature intended that or not. And as I think the court is well aware, brief that we cited. We included all of the canons of construction. The court is interpreting. The court is interpreting. And one of those rules is the rules of leniency. One of those rules is the rules of leniency rule. And the leniency rule, if there is a distinction to be made, if there is a distinction to be made, if there is an ambiguous statute, the interpretation that is most lenient to the court must defend it is the one the court must adopt. That adoption would be that the statute would be that in effect that was amended and sentencing at the time is that Carly sentence is life. Is that Carly sentence is possibility of parole with the possibility of parole. Quick point. I'd like to make that quick point. I'd like to address. Also, Your Honor, I'd like to address. Your Honors, I'd like to address on Johnson v. State's reliance on Johnson v. State. 2 points I'd really like to make about that. 2 points I'd really like to make about that. Number one, I believe. Number one, was Justice Coleman who pointed out. I believe it was Justice Coleman who pointed out was decided well prior to. Was decided well prior to. The amendments to the statutes and amendments to the statutes and possibly to Miller in response possibly to Miller. That case involved. But that case involved thorough sentencing hearing. Sentencing. That is distinguished from this case. That is distinguished from this case because there was no hearing. There was, and again, I've used that term loosely. There was again, I've used that term loosely. There was a very sentencing hearing. In effect, there was a sentencing argument. In effect, it was a sentencing. So in the case at bar. So unlike in Johnson, we had no. Unlike in Johnson, we had no. I believe Miller sentencing hearing, and I believe Miller proposition not only stands for the proposition that there are certain factors that prior effect or whoever's deciding prior effect or whoever's deciding. You can't just throw all these factors. You can't just throw all these factors at the wall. The jury must consider at the wall. Consider them and assume that they're going to consider. So there's a substantive aspect to Miller. There's a substantive aspect to Miller, but there's also a procedural. In other words, the defendant given is the adequate process, adequate opportunity to address those Miller address those Miller. In this case, factors. There was absolutely no notice that there was moving into no notice that I'm not moving into the sentencing prior to the court turning to the state prior to the court turning. Present your first sentencing witness. Present your first sentencing witness. I'm not sure whether the litigants were even aware that I certainly don't see any. In the record, don't see anything in the record where the sentencing order or anything like that outlined. Sentencing order or anything like that outlined. Certainly going to happen. The defense was not certainly afforded. The defense was any due process. Any due process those Miller factors to address those Miller factors. And so we would move. And so we would move. Posit that Johnson is really posit that Johnson is really Carly's case. Another issue that we would point out. Another issue that we would just going to read from our brief. I'm just going to read from my state's reliance on Johnson v. State is misguided. According to the state, I'm quoting from. According to the state, and I'm quoting from this court held in Johnson. State's brief. This court held in Johnson. Application of section 4773 to section 4773 to sentence Johnson when he committed first-degree murder to life. He committed first-degree murder to life in prison after a Miller hearing. After was not an abuse of discretion. Was not an abuse of discretion. In harmony with Miller, section 97. Harmony with Miller, section 97.3.21.2b. Carly Gregg's jury to sentence her to life without with section 47 with 7.3d, which is a parole statute. 7.3d, which is only after it considered the Miller factor. However, Miller factor. The trial in Johnson occurred in 2000. Coleman and Justice Sullivan and Justice Sullivan and pointed that out. The trial in Johnson occurred in 2000. Trial in Johnson occurred in 2000, nearly 2.5 decades prior to the amendment to 97.321. Senate Bill 2022 of our legislature's regular session in 2024. And now, if I may, we did not address this. If I may, we did not address this in the initial argument. But I would one of the errors that we have alleged, did object to.
The defense
And that
did
was
object
the
to.
introduction,
And that was
of
the
the
introduction
crime and punishment summation by
crime and punishment summation
Rebecca
by,
Kirk, who was one of Carly's counsel.
Rebecca Kirk, who was one of Carly's
Um,
counsel.
During the state's rebuttal case.
During the state's rebuttal case,
The state
elicited testimony
state
from
elicited testimony
Rebecca Kirk,
from,
who was again one of Carly's
Rebecca
counselors,
Kirk, who was again
who
one of Carly's
summarized-
counselors.
Well,
Who
first she was asked
summarized-
what books Carly
well,
had
first she
read
was
or
asked
was
what
going
books
to
Carly had
read,
read or was
and there were
going to
several
read.
books that were mentioned.
And there were several books that were
One of them
mentioned.
was one of them
the Bell
was
Jar.
Another was the Bell
Castle.
Jar. Another was the
and then there was
Castle.
Crime and Punishment.
And then there was Crime and
Curiously,
Punishment.
the state did not ask
Curiously,
Rebecca
the
Kirk
state did not
to
ask
summarize
Rebecca
the Castle
Kirk
or the
to
Bell
summarize
Jar.
the
The only
Castle
one that they
or the
asked
Bell Jar.
Rebecca
The only
Kirk
one that
to
they
summarize
asked
Rebecca Kirk
was
to
Crime and
summarize
Punishment. Was Crime and Punishment.
And this was over objection.
And this was
defense
over
counsel.
objection.
And this was
defense
over
counsel.
objection of
And
defense
this was
counsel
over
after
objection
pointing out
of
to the
defense
trial
counsel
court after pointing out
that
to the
there's
trial
no proof
court
that Carly even
that
read.
there's no proof that
the
Carly
book at
even
the time
read
of the trial.
the book at the time of the
Now,
trial.
we would dispute whether or not that,
Now,
that
we
was
would
ever
dispute
established.
whether or
I
not
think
that
that was ever
in
established. I think
cross-examination,
I think
in
defense counsel
cross-examination,
got-
I think
Miss
defense counsel
Kirk
admit that
Miss
maybe
Kirk
she
to
said she was going to
admit
read
that
it, but she
maybe she said she was going to
definitively
read
read
it
it or not,
but whether she had read the
definitively
book
read
or
it or
not
not,
is
but whether
really
she had read the
irrelevant.
book or not is really irrelevant.
The plot of that book was a sensational
The plot
plot.
of that book was a
as
sensational
summarized
plot
by Rebecca Kirk.
as summarized
It was
by
about
Rebecca
a-
Kirk.
it was
a
about
hatchet
a
wielding
murderer
hatchet
who
wielding
tried to
murderer
assert the defense
who
of insanity
tried to
and
assert
got away with
defense
it,
of insanity
and
and
got
got
away
away
with
with
it,
unremorseful and unrepentant.
was unremorseful and
That was a
unrepentant.
summation of Rebecca Kirk. Now,
That was a summation of
not
Rebecca
only
Kirk.
would we
Not only would we
assert that that was an incorrect
assert that that was an incorrect
recitation of the actual
recitation of the actual
but at the
book.
very least,
But at the very least, it was the important points that Rebecca Kirk
the
remembered
important
about the
points that
book. It was
Rebecca
not the
Kirk
important
remembered about
points
the book. It was
that
not the
perhaps
important
Carly Gregg
points
would have
that
remembered
perhaps
about the
Carly
book.
Gregg would have
But
remembered
be that
about
as
the
it
book.
may, the only reason
Be
that
that
the
as it may,
prosecution
the
would
only
want
reason
Rebecca
that the
Kirk
prosecution would
summarize
want
that
Rebecca
book is
Kirk
because the
summarize
prosecution
that book is because the
wanted that
prosecution
jury
to hear
wanted
those
that
sordid
jury
details
those
about that
sordid
book and associate
details about that book,
those
and associate
details
with Carly Gregg.
those
They
details
wanted the jury
with
to
Carly
think, well,
Gregg.
if she read
They
that
wanted
book,
the jury to think, well, if she
she
read
must
that
have been
book,
she must have
she
had
must
those
have been
thoughts.
she must have
had
hatched
those
the plot
thoughts
to
She
plead
must have
insanity
hatched the plot
after
to
she read
plead
that book.
insanity
That is exactly
after
what
she read that book.
That is
Prosecution
exactly
wanted
what
the jury to believe. And that was
prosecution
over
wanted
the
the jury
objection
to
of the
believe.
defense.
That was over the objection of the defense.
Now, I believe it was Justice.
Now, I believe it was Justice King, and I believe Justice
Justice
Coleman
King,
joined.
and I
I
believe
believe
Justice
Justice Coleman
joined
joined
Justice
Justice
King
King in an objection in Jordan v. State, which was an en banc split decision by this court rendered in 2016, which was reviewing affirmation of an appeal, appellate affirmation Court of Appeals affirmed, the Court of Appeals affirmed a finding of guilt after
guilt,
the
prosecution was
allowed to introduce rap lyrics. The
Court of Appeals
affirmed the conviction,
affirmed
and then
the
Supreme
conviction,
Court,
and then the
was
Supreme
split
Court
evenly 4-4 again.
split
Justice
evenly
King
4-4
followed
again.
an objection.
Justice
King
Coleman, I believe,
followed
joined in that objection.
Justice Coleman, I believe, joined in that objection.
And
there were several things that
Justice King
that,
cited in his
Justice
objection.
King cited in his objection. And I believe that court sided with. And I believe that court sided
approval
with
a
New Jersey
approval
case, State versus
New
Skinner.
Jersey case, State
In that
versus
holding in
Skinner.
State versus Skinner.
In that holding in
the
State
New Jersey
versus
Supreme
Skinner,
Court.
the New
held
Jersey
that
Supreme
lyrics
Court
were highly
held that
prejudicial.
lyrics
carried
were
little
highly
or no
prejudicial,
probative
and
value
carried
because
little
they
or
were
no
expressive,
probative value because
fictional
they were
writings,
expressive
and not tied
fictional
by a
writings,
strong nexus
and not
to the
tied by a
charged
strong
shooting in
nexus
that
to the
case.
charged shooting.
Just as in this case, there is no nexus.
Just as in this
between
case, there is no
what
nexus
a-
between
what the writer of Crime
what
and Punishment
what the
wrote,
writer of Crime
and
and
what
Punishment
was
wrote
alleged that Carly
and what
did.
was
There was no
alleged
nexus
that Carly
did.
did.
Not
There
even
was no
established
nexus
that she had read the book.
Not even established
And
that
I want
she
to
had
read
read
a
the book.
quote, and I want to read a
Because I think
quote.
it's
because I
extremely
think it's instructive, extremely
State
instructive
versus Skinner.
from State versus Skinner.
The difficulty in identifying
The
probative
difficulty
value
in
in
identifying
fictional or other
probative value
forms of
in fictional or other forms
artistic
of
endeavor
artistic
is
self-expressive
that one
endeavor
cannot presume
is that one cannot
simply
presume
because
that
an author has chosen
simply
to write
because an
about
author
certain
has
topics.
chosen
He
to
or
write
she
about
has
certain
acted in
topics.
accordance
He or
with
she
those
has
views.
acted in accordance with
One
those
would not
views.
presume that Bob Marley,
One would not
who wrote presume that
well-known
Bob
song,
Marley,
"I
who
Shot the
wrote the
Sheriff,"
well-known
actually
song,
shot a
"I Shot the
sheriff.
Sheriff,"
Or
actually
that
shot a
Edgar
sheriff.
Allan Poe buried
Or
a
that
man
Edgar
beneath
Allan
his
Poe
floorboards
buried
as
a man
depicted
beneath
in
his
his short
floorboards
story,
as depicted
The Telltale
in his short
Heart.
story,
Simply
The Telltale
because of
Heart.
their respective
Simply
artistic
because of their
endeavors
respective
on those
artistic
subjects.
endeavors,
The
on those
defendant, in
subjects.
that case,
The
lyrics should
defendant, in
receive
that
no
case,
different
lyrics
treatment.
should receive
In
no
sum,
different treatment.
we reject the
In
proposition
sum,
that
we
probative
reject the
evidence
proposition
about a
that
charge of
probative
offense
evidence
can be
about
found
a
in an
charged
individual's
offense can be
artistic
found in an
endeavors,
individual's
absent
artistic
a strong
endeavors,
nexus between the
absent a
specific
strong
details
nexus
of the
between the
artistic
specific
composition
details of the artistic
and the
composition
circumstances of the
and the
offense
circumstances of the
being
offense for
adduced.
which the evidence is being adduced.
And I would take that a step further.
And I would take that a
case,
step
in-
further.
In these cases
That
that
case,
we
these
cited in our
cases
brief,
that,
including Jordan
we
v.
cited in
State,
our brief,
Brooks
including Jordan v. State, Brooks
United
v.
States v.
State,
v. Curtin,
United States v. Curtin,
involved
that the defendant was alleged to have written or participated in some form or fashion.
In Carly's case, is a book that she had absolutely nothing to do with writing.
Absolutely nothing
She did not
to do
write that
with
book.
writing.
She did not
She
write
had
that
absolutely
book.
no contribution.
She had
to the
absolutely
themes
no
that were found
contribution
in that
to
book.
the themes that were found in that book.
So we would submit that
proposition cited in the proposition cited Justice King and Jordan v. State, Justice King and Jordan v. State, Jersey Court and State v. Skinner, Jersey Court and State v.
the Ninth
Skinner,
Circuit and United States v.
the Ninth
Curtin are
Circuit
even
and
more
United States v.
applicable
Curtin are even more
in
applicable
the case at bar than they were in
in the
those
case
cases.
at bar.
We would argue that the court
we would
erred
argue
in allowing the
court
state to
erred
introduce
in
that
allowing the
testimony.
state to introduce
Thank
that
you, Mr.
testimony.
Murphy. Thank you, Mr. Murphy.
And if there are no other questions, by the justices, thank you, Your Honors.
Ms. Hartman, Mr. Murphy mentioned the crime and punishment argument during his initial presentation. Out of a sense of fairness, you'd like an opportunity to respond to that. The court will give you a couple of minutes.
May it please the court. May it please the court. So the majority of Gregg's argument for crime and punishment essentially is relevant, and that any relevance it did have was probative. Prejudicial than probative. That's not the standard. The standard is under 403. The standard is under probative value is substantially outweighed by the risk of unfair prejudice. By the risk of
Counselor,
unfair
first you do
prejudice.
have to answer the relevance. Counselor, first you do have to
Yes,
answer
Your
the
Honor.
relevance question.
Yes, Your Honor.
So there's no evidence that
I would
Ms. Gregg
disagree
read
with
that
that,
book,
Your Honor.
correct?
I would disagree with that, Your Honor.
She said she
and-
told the
she said
counselor she wanted to. She told the
And then she
counselor
told her
wanted
that
to
she
read.
completed the
And
reading.
then she told her that she completed the
reading.
Where is that? She did say that. I'm
Yes.
sorry. Where is that in the record?
Let me see if I have that written exactly down here. I don't have that citation. I don't have that citation on my outline, but it is in our brief. My outline, but it is in our brief. In the brief. So I know that I cited it there. So I know that I cited it essentially. And Rebecca Kirk and Greg discussed those three books before spring break, and then they went on spring break, and then they went on spring break, right after spring break. Appointment right after Rebecca Kirk that she had completed the reading. Rebecca Kirk that she had completed the reading. It's a fair inference that she read the book. It's a fair
And I'm sure you're correct. I'm sure that's in there. And I'm sure you're correct. I'm sure that's in there.
So assuming that it is,
Still ask the question, what
disputed fact,
her reading of the,
case
or the
does that-
report
her
that she
reading
read
of
that book,
the-
make
or the
more or less
report that
likely
she
to be
read
true?
that book make more or less likely to be
I
true?
think because defense put on an insanity defense, and they called Dr. Clark to the stand to testify that Greg was criminally insane under monotony. He testified that he relied on Rebecca Kirk's, and then the state called Rebecca Kirk, to Greg's insanity defense and Greg's insanity testimony about her monotony testimony. So it's our contention that that's relevant. Her state of mind, that's relevant. Her state of mind, the materials she was ingesting, discussions she was having with her therapist, even about these difficult, complicated classic books. Rebecca Kirk's testimony about Rebecca Kirk's testimony about even just 24 hours before Greg went and murdered her mom. So I think that Rebecca Kirk's treatment notes, including that reference, are relevant to the state's rebuttal of her insanity defense. And Your Honors, even if this court And Your
is
Honors, even
inclined
if this
to hold
court
that Rebecca
is
Kirk
inclined
should
to
not have
hold
been
that Rebecca
permitted
Kirk
to
should not have
testify
been
about
permitted to
the summary
testify
of crime and
about
punishment,
the
I
summary
think this
of
is a
crime and
classic
punishment.
example
I think
of
this is a
harmless error
classic example
because
of
Greg
harmless
was
error
not
because
convicted because
Greg was
Rebecca
not
Kirk
convicted because
summarized
Rebecca
crime and
Kirk
punishment on the stand.
summarized crime
She was
and punishment on the
convicted
stand.
because the state
She was
presented
convicted because the
extensive
state
and overwhelming
presented
evidence
extensive and
that
overwhelming
she was
evidence that
same
she was
at the time when she murdered her
same
mom,
at the time
and
when
that
she
she
murdered
committed
her
the murder
mom,
with deliberate
and that
design.
she committed the murder with
Just a
deliberate
few
design.
examples.
Just a
She
few examples.
appreciated where the
She
security cameras
appreciated
were in the
where the
kitchen.
security cameras
She
were in
hid
the
the gun
kitchen.
behind her
She
back
hid the
when
gun
she was
behind
in view
her
of the security
back when she
cameras
was in view
so
of
the
the
camera
security
wouldn't see it.
cameras.
She
So the
covered her
camera
mom's
wouldn't see
face
it.
with a towel.
She covered her
after
mom's
shot
face
her
with a
point blank
towel
in the
after
face
she
3
shot her
times.
point blank
She
in the
called
face
multiple
3
friends
times.
on the
She
phone.
called multiple
and
friends
said
on the
things like,
phone.
I messed
and said
up.
things like,
I
"Don't
messed
call the
up.
police."
Things
Don't
that
call
would
the
indicate
police.
that she knew what
Things
she
that
had
would
done
indicate
was
that
wrong.
she knew what she had done.
She even took
was
her mom's
wrong.
cell phone off
She
the
even
counter
took her
right
mom's
after
cell
she
phone
murdered
off
her,
the counter,
put in
right
the
after
correct
she murdered her,
passcode, put
and
in the
then
correct passcode,
went in the phone, found
and
Heath's
then
contact
went in the
information,
phone, found
and
Heath's
texted him,
contact
and asked when he would
information,
be
and
home,
texted him,
like
and asked when
Ashley.
he would be home, acting
This
like
and
Ashley.
abundance of other examples.
This and abundance
prove
of other
that Greg
examples
murdered her mom
prove
with
that
deliberate
Greg
design,
murdered her
but more
mom with
importantly,
deliberate
that
design,
she
but more importantly,
understood the
that she
difference between
understood
right and
understood the
wrong
difference
when she
between
murdered her
right
mom.
and wrong
So she was
when she
sane
murdered her
under
mom.
monotony.
So she was sane
So
under
irrespective
monotony.
of the crime
So
and punishment
irrespective
summary,
of the
Greg
crime and
would have been
punishment summary,
convicted.
Greg
and
would
this
have been
court should
convicted,
affirm her convictions
and this
and
court should
sentences.
affirm her convictions and sentences.
Thank you, Your Honors.